In this video, I'm going to answer the question, is bullying at work unlawful? The answer is sometimes. Keep watching and I'll reveal exactly when it is and how much money these cases are worth. When analyzing this area of law, you must first understand that there is a significant difference between things that are unfair and things that are unlawful. Just because somebody is bullying you does not mean that the law is being broken. And before we can talk about how much bullying cases are worth, we first need to establish when things are unlawful, because you can't win anything unless a law is broken first. Most states in America say that unlawful bullying and harassment occurs when the following 4 elements are met. Number 1, either a supervisor is doing the bullying, or a coworker was doing it and the employer knew or should have known about it. Number 2, the bullying was severe or pervasive. Number 3, the victim considered the work environment to be abusive. And number 4, the bullying is happening because of a protected characteristic or a protected activity. Let's take a look at each of those elements carefully. Element number 1, to be unlawful, the bullying at issue must have been done by a managerial employee or a coworker. If it was done by a manager, in that case the employer is automatically liable for their actions. But if it was done by a coworker, then your lawyer is going to have to show that the company knew that the conduct was happening or should have known that the conduct was happening and failed to take any action to stop it. The moral of this element, of this story, is that if a coworker is bullying you, you need to complain to HR to put the company on notice that it's happening. Then, if they fail to put a stop to the harassment, that is when the company becomes liable, so long as all the other elements are met. Next, the bullying that you are suffering must be either severe or it must be pervasive. We get calls all the time from people who are upset that their boss is teasing them slightly about their shoes or their personality quirks or something else that is fairly benign. Generally, that is not enough. For behavior to be unlawful, it must be very serious or intense, or it must be widely spread throughout the organization so that the conduct happens over and over and over. So, if the bully made one joke about you, usually that is not enough to become unlawful. It has to be really serious, or it has to happen over and over and over again so much that it creates an abusive working environment. Next, you, the victim, must consider the bullying to be abusive. While this sounds obvious, right? I can't tell you how many people have called my office complaining about a hostile work environment, but when we dig into the facts, it turns out that this person wasn't offended at all. They never complained about it. In fact, sometimes they tried to bully the bad guy back. The bigger issue with this element is proving that you, the victim, considered it abusive. It's very hard to believe that you found the behavior to be unwelcome when you never complained about it, never went to HR, and never even asked the bully to stop. If there are no documents, emails, or text messages that suggest that you found this behavior to be offensive, it's going to be really hard to convince a jury of your peers that you should be paid for it. The last element is a big one that trips up a lot of people. To be unlawful, the bully must be targeting you because either you have a legally protected characteristic or you participated in a legally protected activity. Let me put this all another way. The bullying that you are suffering is legal unless you are being targeted because you have a characteristic protected by law or because you participated in an activity protected by law. Okay, so what are these protected characteristics and activities? Great question. Let's look at the characteristics first. The federal minimum, which applies to every employer across the United States with more than 15 employees, includes things like race, color, religion, sex, which includes pregnancy, national origin, age, if you're 40 or over, disability, and genetic information. These characteristics are set up by massive federal laws. But wait, there's more. Your state might have additional characteristics because states pass their own laws. For example, in California, where I practice law, if the employer has more than 5 employees, the Fair Employment and Housing Act, which is a big state law here, incorporates the federal minimum characteristics, and it adds things like military or veteran status, sexual orientation, marital status, medical condition, gender identity, gender expression, and ancestry. So if you're being bullied because of one of those categories of characteristics, the company is breaking the law. Next, let's look at the protected activities, okay? Your boss or coworkers are not allowed to bully you because you did one of the following things. Refuse to violate a law. Went on a protected leave of absence under FMLA. Complain about something that was unsafe. Complain that you or somebody else was being discriminated against or harassed because of one of those protected characteristics. If you requested a reasonable accommodation for a disability or something like that. If you testified in court or served on jury duty. If you complained about an OSHA violation. If you blew the whistle on unlawful billing practices or unlawful bills being sent to the government. And there's a whole lot more than that. That's just the tip of the iceberg. Now this protected characteristic, protected activity element trips up a lot of people. It seems unfair that someone can be bullied by somebody at work, and so long as it's not because of one of these characteristics or activities, it's perfectly legal. Yeah, I agree. The law is not perfect on this, and something should be done to fix it. With that said, don't get mad at me. I don't make the laws. We just try to use them to help our clients. If you're getting value out of this video, please click the subscribe button. I make videos about employee rights, and if you want to stay in the loop, click the button. Before I talk about the last element, I should say something really important. I have a license to practice law in California, but a lot of people who see my videos want to contact me. That's great, but the free consultation process at my office is for California workers who got fired and they believe that they have a case for harassment, retaliation, discrimination, or wrongful termination. If that applies to you and you think I've earned your phone call, please don't be afraid to give me a call for a free consultation. Now that you know when bullying becomes unlawful, we next need to discuss what you should do about it. The way I see it, you've got 4 options. You can do nothing, you can complain about it, you can quit your job, or you can take legal action. Let's take those in order. If you believe that the law is being broken, doing nothing is never a good option, right? If you do nothing, the bad guy is going to continue to bully you, and he is likely to bully somebody else if he's not stopped, okay? What about complaining about it? Well, if the bullying is legal, I would only submit a complaint to HR if you believe you would quickly be able to get a new job in case your boss decides to retaliate against you. On the other hand, if the bullying is unlawful, I strongly recommend that you submit a complaint correctly to HR and make sure you do it in writing. Submitting a complaint like this will provide you with more legal ammunition if you get fired down the road. But let me warn you, it can be very dangerous to complain to management about bullying. I strongly recommend that you watch my 2-part video series on how to complain properly to HR, in which I'll link to those videos at the end. The knowledge in those videos will help you complain properly so that you minimize the risks that come with complaining. 3, you could quit, right? You could just leave. Now, I rarely advise that people quit a job in response to bullying. When you quit, you hurt your legal case for damages. The only time I advise this is if that person has another job lined up so that they can quickly replace their income. Or sometimes I advise it if the bullying that they were suffering is severe, but that is rare and only applies in truly extraordinary cases. Well, okay, what about taking legal action? Obviously, if no laws are being broken, you don't need to call a lawyer and take any kind of legal action. However, if you believe the law is being broken, I recommend that you do the following. If you are still employed, I recommend that you complain about the bullying in writing to HR or management. Again, watch my videos on the proper way to complain to HR before you go ahead and do it. If you got fired, on the other hand, I recommend that you call a lawyer to see if you have a case that should be pursued. If you quit, I would only recommend that you call a lawyer if the bullying you suffered was severe. Because remember, if you quit, your case becomes much harder to pursue because you're probably not going to be able to collect your lost wages, which are really important in employment cases. But if the bullying was truly horrible, it might still be worth taking action even though you quit. Before we talk about settlement value, let me say one quick thing that I forgot to mention at the start of the video. I have a license to practice law in California, but this video should not be taken as legal advice for your situation. If you need legal advice, call a lawyer in your state. Okay, let's talk about money. How much money are bullying cases worth? Well, the honest answer is that it depends. It can be worth nothing and it can be worth millions. It depends on a lot of factors like how severe was the bullying? Did the company encourage it? How harmed are you, the victim? Is there good liability? Do you have a good lawyer? Are there witnesses that'll support your claim? Did you complain about the bullying? Are there other victims? Did you get fired? And the list goes on and on. Now, I recently released a video called How to Get a 7-Figure Settlement. In that video, I dive deep into the factors that go into settling big cases. I carefully examine the types of damages you are entitled to. Now, it's a long video, admittedly, but I highly recommend that you watch every second of it because you'll get a far more complete picture of what these cases are worth. Beyond that, the best way to find out if you have a case and how much it's worth is to pick up the phone and call a lawyer in your state. If you want to contact me, remember the free consultation process at my office is for California workers who got fired and they believe that they have a case for harassment, retaliation, discrimination, or wrongful termination. If that applies to you and you think I've earned your phone call, please don't be afraid to call my office for a free consultation. If you're being bullied right now, I hope this video has provided you with some insight into your legal rights. While the law definitely does not offer perfect solutions to those who are still employed, if you complain in writing, if you keep things documented, and you continue performing your job at a high level, you might protect yourself in a significant way. If you are still employed, I also strongly recommend that you watch my video series called How to Document Bad Behavior at Work. In those videos, I talk about taking notes, saving emails, saving text messages, and saving important company documents. I strongly recommend that you watch those videos. They are linked below in the description. All right, that is all I have for you. Hit the like button. Please subscribe to my channel for future employment law updates. Take care.